The Supreme Court just gutted the Clean Water Act. It could be devastating. Justice Antonin Scalia died more than 7 years ago, but the Supreme Court's decision in Sackett v. Environmental Protection Agency on Thursday shows that this is the Scalia Court far more so than when he was alive. The ruling arrives almost a year after the court's conservative majority made the worst fears of environmentalists a reality in West Virginia v. Environmental Protection Agency, which severely curtailed the ability of the nation's environmental laws to protect public health and welfare. The Sackett ruling doubled down on that disregard for pollution and public health, and the effect will likely be devastating. The precise legal issue decided in Sackett concerns the geographic scope of the 1972 Clean Water Act. Congress intended the law to end the practice of the nation's waterways being used as the unregulated dumping ground for industrial pollution. The effect was transformational. For the first time in the nation's history, any discharge of pollutants into the nation's waterways absent a permit was unlawful, making it possible to safely fish and swim waters throughout the country. Congress was not at all shy about the geographic reach of the Clean Water Act. The statute targeted discharges into navigable waters, but Congress also expressly defined that to include all waters of the United States. Since the mid-1970s, the courts have uniformly agreed that Congress intended with that expansive definition to extend the law's protections far beyond traditional navigable waters to include the wetlands, intermittent streams and other tributaries that feed into the nation's major rivers and lakes. In a unanimous opinion for the court almost 40 years ago, Justice Byron White explained why. While acknowledging that, on a purely linguistic level, it may appear unreasonable to classify lands wet or otherwise as waters, the court said, such a simplistic response does justice neither to the problem faced by the government, nor to the realities of the problem of water pollution that the Clean Water Act was intended to combat. Justice Samuel A. Alito Jr.'s opinion in Sackett, however, embraces the very simplistic response that the court rightly criticized in 1985. Relying on a dictionary definition of waters and ignoring the Clean Water Act's purpose, the court's conservative majority has adopted a radically truncated view of the reach of the law's restriction on water pollution. Under the court's new view, pollution requires a permit only if it is discharged into waters that are relatively permanent, standing or continuously flowing bodies of water, forming geographic features that are described in ordinary parlance as streams, oceans, rivers, and lakes. And wetlands are covered only if they are indistinguishably part of those narrowly defined covered waters. This is exactly what Scalia wanted to accomplish in 2006 when the Clean Water Act was last before the court. He managed to cobble together 3 other votes to gut the law but fell 1 justice short. Now, with 6 conservative justices, 3 of whom are largely modeled after Scalia, Alito was able to accomplish what Scalia never could by securing the necessary 5th vote. The impact of the majority ruling is potentially enormous. It could lead to the removal of millions of miles of streams and millions of acres of wetlands from the law's direct protection. Basic protections necessary to ensure clean, healthy water for human consumption and enjoyment will be lost. As highlighted by Justice Elena Kagan's separate opinion, the court's opinion prevents the EPA from keeping our country's waters clean by regulating adjacent wetlands. Nor will the nation's economy be spared. Myriad businesses rely on clean water for their industrial processes. The fishing, real estate and tourism industries are all highly dependent on the protections that the Clean Water Act has provided over the past half-century. None of this was compelled by law. Even Justice Brett M. Kavanaugh rejected Alito's majority view, announcing that he would stick to the text. Congress spoke clearly in the Clean Water Act about its ambitions and backed that intent up with deliberately sweeping language to provide the EPA with the discretionary authority it needed to realize those goals. Our nation's waters are far cleaner as a result. Yet, for the second time in less than a year, an activist Supreme Court has deployed the false label of separation of powers to deny the other 2 branches the legal tools they require to safeguard the public. Scalia might have been pleased. Our nation should not be. DeSantis should learn from one of the biggest blunders in American marketing. Wednesday evening's overthought and underprepared glitch festival on Twitter Spaces was at least a fitting coda to the preceding months. If Ron DeSantis does not win his party's presidential nomination, his pre-announcement campaign will be remembered for making a sow's ear out of a silk purse. Beginning with many advantages, the Florida governor spent months diminishing himself by positioning. Congress decides what it can investigate, not Harlan Crow. Harlan Crow, the Texas billionaire who lavished gifts and favors on Supreme Court Justice Clarence Thomas, isn't a member of Congress, but Crow, through his lawyer, asserts that Congress lacks a valid legislative purpose in seeking information about their relationship. Crow isn't a Supreme Court justice, but he also asserts that Congress would be violating the constitutional separation of powers if it were to dare to apply ethics rules to the High Court. Crow attorney Michael D. Bob sent a high-handed letter to the Senate Judiciary Committee Monday that could be condensed to 2 words: go away. The committee, led by Senator Richard J. Durbin, Democrat Illinois, had written Crow on May 9 asking for the information as part of the committee's ongoing efforts to craft legislation strengthening the ethical rules and standards that apply to the justices of the Supreme Court. It sought a list of gifts, travel and lodging Crow or his entities had provided to any justices, plus any real estate transactions. In other words, what else is out there? After careful consideration, we do not believe the committee has the authority to investigate Mr. Crow's personal friendship with Justice Clarence Thomas, Bob responded. Most importantly, Congress does not have the constitutional power to impose ethics rules and standards on the Supreme Court. Doing so would exceed Congress Article 1 authority and violate basic separation of powers principles. Bob's letter is unlikely to be the last word. There's a regular give and take between members of Congress and the subjects of their inquiries. That's fine. Being told to bug off is another matter. Being told to bug off because the subject of the inquiry has determined for himself what the Constitution has to say about the matter takes things to a new level. The obvious response here is a subpoena, but that step will be complicated, among other things because of Democrats' precarious majority, committee rules that empower Republicans to block action from their minority perch and the prospect of time-consuming efforts to ensure compliance. All of which makes a summons a rickety bridge to cross. But first, let's back up and consider why Crow's argument is so wrong. Bob contends that the panel can't have a valid legislative purpose because it can't legislate ethics rules for the High Court. His letter gives no reasonable people can differ ground on this contested topic, it simply asserts the impermissibility of legislating in this area. Former federal judge J. Michael Luttig, an esteemed conservative, told the Judiciary Committee this month that Congress indisputably has the power to set ethics rules for the High Court. Others disagree. Ultimately, the constitutionality of any such move would be decided by the justices themselves. Unless and until that